Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about ostriches. Cases that should have gone to the Supreme Court of Canada, but didn't. There was a lot of attention across Canada to the case of an ostrich farm in British Columbia, and in particular, an order made by the minister that the ostriches at the farm be executed. The reason for this had to do with the avian flu outbreak. Some of the ostriches at the farm had tested positive for avian flu, and the government was asked to test every ostrich, but refused to do so on the basis of the fact that it wasn't necessary. All of them, by the application of policies related to food, health, and safety, needed to be destroyed. A judicial review was filed of that decision and was unsuccessful in the BC Supreme Court, at the BC Court of Appeal, and ultimately the Supreme Court of Canada denied leave to the judicial review application. And although this case doesn't raise issues of national importance in the sense that the Supreme Court of Canada ordinarily would hear a case because of an important legal issue or to resolve a conflict in the laws between provinces, to clarify an important legal principle, it is still a case where there is such a strong public interest in hearing it that the Supreme Court of Canada, in my opinion, ought to have taken the case. Sometimes there's an issue that is so important to members of the public that even though legally it doesn't actually have any significance, the Supreme Court of Canada should still take the opportunity to hear the matter in order for members of the public to feel heard, in order for members of the public to feel like before something that they find unacceptable happens, that every avenue of redress has been exhausted. And for the Supreme Court of Canada to say, no, we're not going to hear the case, it effectively prevented many people from feeling like they got a fair shake to save the lives of the ostriches. Now, obviously, the ostriches were destined to be executed one way or another because they were being raised for food, but that wasn't the reason the Supreme Court of Canada shouldn't have heard the case. The Supreme Court of Canada ought to have recognized that this was something that mattered to the emotions of Canadians. If you look at the development of constitutional law in Canada, it does relate to things that emotionally engage Canadians. The vast majority of constitutional litigation in Canada has been through tobacco, food, and booze, and driving. And the reason for that is because these are things that people actually feel strongly about because they affect them on their day-to-day lives. And that was what the Supreme Court of Canada failed to recognize here. On the other hand, there is an argument to be made that the Supreme Court of Canada should have denied leave because there wasn't an important legal issue. None of the judgments were legally incorrect, and there was no conflict in laws that needed to be resolved by the court. And by allowing the case to be heard, it would have delayed the execution of the ostriches further. But to the extent that this argument is being advanced, the Supreme Court of Canada does retain power to truncate the timelines and to order the hearing proceed on an expedited basis. So they could still have had the best of both worlds. And so although this case legally isn't that interesting at all, the case is still significant, and it becomes effectively an issue of national importance where members of the nation view it as important, despite its really lackluster legal precedent. It's unfortunate the Supreme Court of Canada didn't recognize that sometimes their role extends beyond the black letter of the law and into the hearts and minds of Canadians. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Please like, subscribe, and share with your friends.